Good morning, everybody. Welcome to this in-house lawyers forum on electric vehicle charging infrastructure, known as EVCI. We've got quite a broad range of attendees today, predominantly public and private sectors. So we're going to try and cover both public and private sort of sector considerations, and we're looking at each of the topics. There should be something for everybody. There will be a Q&A function, which I'll mention again in the chat. So we've got time for Q&A at the very end. So do feel free to use the Q&A function rather than the chat function, and we'll pick those up towards the end. And if we don't get to all of the questions, we will come back to you separately afterwards. Your speakers today are myself. My name is Michael Bray. I am a real estate partner, and I chair the National Clean Energy Real Estate team and also the Transport Sector team here at Freeze, and EVCI sits very nicely between those two. And then we'll hear from Coralie McIver, who's a director in the real estate team who specialises in energy and also EVCI. And we're very lucky to have a knowledge management lawyer specialising 100% in clean energy and EVCI, Shreya, who's also joining us today. Then we have Tom Johnson, a partner in our transport team, who also has lots of experience of EVCI, and we'll hear from him. And then finally, we'll have Emma Whitfield, hopefully, managing associate in the commercial team. She's en route for another meeting, stuck in traffic, but hopefully she'll be here before her slot towards the end, talking about clean energy and in particular procuring EV as a service. So our agenda today, I'll give a quick overview of EV charging infrastructure and what that kind of looks and feels like, and we'll be focusing mostly on non-highway land, so car parks and that sort of thing, as opposed to sort of on-street EVCI, but we will talk about that a little bit as well as we go along. And then we'll be looking at the real estate considerations for EVCI, and in particular sort of leases to what we call charge point operators or CPOs, and some of the considerations that the CPOs need to ensure in those leases for bankability reasons. And then we'll be looking at it from a landowner / sort of local authority point of view in terms of if you're granting those leases or approving tenants on your estate, entering into those leases, what sorts of practical things should you be thinking about? Then we'll hear from Shreya on power strategy and sort of energization and how that kind of works. And then we'll be hearing from Tom on asset leasing and asset and project financing in this context, before hopefully Emma joins us to talk about procurement. And as I said, we're going to look at both sort of the public and private angles in that. Lots of acronyms in the EV sector, so I thought I'd start by putting a few of them on the slide. We won't be using all of them in this session. There are many more, but the key ones for us are obviously EV, which is the electric vehicle itself. When we talk about EVCI, we mean the EV charging infrastructure as opposed to the EV. You've got BEVs, which are quite simply the battery electric vehicle. You've got PHEVs, they're plug-in hybrid electric vehicles. You've got LEVs, low emissions vehicles, and that includes hybrids and modern and petrol diesel cars, which we're probably all quite familiar with sort of the low emission zones being rolled out across the country. Then you've got your ULEVs, your ultra low emissions vehicles, and that includes your battery electric vehicles, your plug-in hybrids, and also hydrogen. And then for the planners out there, the CPO in this context means charge point operator as opposed to compulsory purchase order. That's kind of the tenant under an EVCI lease. And then PPAs, which we're talking about sort of power purchase agreements when you're sort of buying the power to energize these EVCI. So EVCI can come in many different forms, and I've picked sort of the four sort of key examples there on this slide to sort of talk you through. So from left to right, we're looking at sort of your EV forecourt or motorway services style arrangement where you've got a bank of EV charge ports, and you might pull up your car, plug in, and then go and have a coffee or use the facilities or something whilst your car is charging, whilst you're typically en route to somewhere. The next slide, the next picture is sort of an example of electricity generation alongside EV charging infrastructure. So it could be off-site ground-mounted solar or something coming in privately, but we are seeing some examples of solar carports where you're putting solar panels above car parking spaces served by EV charging infrastructure, which could be fed directly from the solar, or the solar could just be there above them just to sort of utilize the space and feed something out. But we are seeing that a lot too. The next picture there, sort of very straightforward, sort of your sort of home or office, a wall-mounted charger, sort of very simple from a sort of a legal regulatory point of view, but that's another example. And then finally on the far right, you've got your on-street charging, which we've all seen, I'm sure. And I'm just going to hand it over to Shreya now to sort of talk us through this slide again to set the scene on sort of a typical power structure for an office or industrial type building with EV. Shreya?
Yeah, sure. Thanks, Michael. So to bring this to life a bit with sort of the typical example of what we're seeing. So you might have, I guess, a warehouse or even a sort of shopping center or a leisure center with some EV charging infrastructure alongside some on-site energy solutions. Actually, if you're a sophisticated EV user yourself at home with a smart meter, then this might be a familiar arrangement to you just on a much larger scale. So in the diagram here, you've got your EVCI where the cars are, which is importing electricity from the public grid, the local distribution network, as well as importing electricity from the on-site battery energy storage system and the on-site rooftop solar panels as well. And then you've got the power from the rooftop solar, and that will actually typically be the best option for charging during the day when it's the sunniest, and in the evening, charging up the EVs from the battery instead. The battery can then in turn also import electricity from the grid, as well as store, for example, some sort of excess midday sun from the rooftop solar to be used later on. And the rooftop solar could even have the ability to export any surplus power back to the grid. So potential here for a lot of different power flows going on, as well as cash flows. Then finally, very important on the software side, the EV charging management software can align with, or it can even be integrated with the energy management software, with the goal being to charge up the EVs in the most efficient way, and again, make the best use of the available on-site energy, that solar and battery that we have on the site. And with that whistle stop tour, I will hand back to you, Michael.
Thank you, Shreya. So that's sort of most of the sort of scene setting, which was useful, sort of a bit of background. And we're now going to move on to some of the more sort of techie side. So starting with the property arrangements. And as I set out on this slide, sort of as a typical leasing model really for EVCI. So you have a landowner, which could be a local authority, leasing land directly to a CPO. And in that scenario, the CPO will install, own, operate, and maintain the charge points. And the capital and operating costs will be borne by the CPO. And the CPO will take most, if not all, of the profits. And they'll pay either a flat, lease rental payment, which could be per space, or there could be a profit share rent entirely, or there could be a combination of the two. And there might be framework agreements or agreements for leases. I mean, typically before you go into lease, you might be looking at CPs like planning and grid and that sort of thing. But also you could have, a multi-site solution. So you could be rolling out, for a pub chain or something, you could have lots of these coming, in which case it's probably a good idea to have a framework agreement which kind of sets which sites are in the mix, how to bring additional sites into the mix, the CPs for each lease, and also sort of contractualizing the templates so that you're not renegotiating leases and other documents from scratch each time. So you might see those too. And also, lastly, there, bringing in power, you might see grid easements and wayleaves and substation leases and things as well, ancillary to the main sort of property lease to the CPO. So we're going to start with sort of the looking at a lease to a CPO and sort of some of the key considerations that a tenant under that lease would be thinking about. And I'm going to hand over to Corey to talk us through some of these key issues.
Thanks, Michael. So on the slide here, we have some of the key considerations for EVCI operators or the tenant under the lease. I won't talk through all of them, so I thought we would focus on the ones in bold today. And essentially, these are things that are key fundability points to consider when acting for the CPO or the tenant. The first one is assignability. So from a CPO perspective, they want to maintain maximum flexibility with their lease and ensure that they can essentially deal with it as they see fit. So typically this will include ensuring that there's no change of control restrictions and ensuring that there's limited restrictions on things like assignment and charging. And in particular, that when there's an assignment, there is no requirement for an authorized guarantee agreement or AGA, as they usually do not wish to guarantee the obligations of a competitor who's the likely choice for an assignee in this scenario. The second point I wanted to highlight was around direct agreements. So this is essentially where there is a funder, and it is standard to require the landlord an obligation to enter into the direct agreement in the form required by the funder to allow them to essentially have step-in rights. And as well as this, there may also be a requirement for a direct agreement with a landowner, which is a slightly different purpose of protecting the CPO where there is a leasehold scenario. And this helps mitigate against the risk of the head lease being forfeited and requires the head landlord to grant a new lease directly to the CPO on the same terms. So there's two different types of direct agreements that you may hear referred to in these types of leases. The third point I want to touch on was the tenant indemnity. And this is in relation to the indemnity that would be given by the CPO under the lease. And the expectation is that this would be limited. Firstly, by a financial cap, which will vary depending on the type of site and the type of charges being installed, and will often be backed by insurance. The other ways that the indemnity can be limited might be excluding economic and consequential losses by including a right for the landlord to mitigate its losses, and sometimes, but less common, allowing the tenant the right to step in and manage any claims. However, it's more common, just given the nature of the sites, that the tenant might have an element of control, such as allowing the tenant to make representations rather than allowing them to actually control the process itself. Next one I wanted to highlight was forfeiture. Where in a scenario where there is a funder or there's intended to be a funder, the forfeiture provisions should also include funder protection provisions, or at least be subject to the terms of any direct agreement that is entered into, whether that's entered into at the same time or in the future. Typically, this will mean that the clause includes a longer period for remedying any breaches, such as non-payment of rent or other non-monetary breaches by the tenant. And you might also wish to consider not including a forfeiture right in the event of insolvency of the tenant if you are the CPO in this scenario. And then the final one I wanted to just touch on was around repair and maintenance of the equipment itself. So from a CPO's perspective, they'll need to give some consideration as to the standard of repair that is required by the lease. Typically, we see that the CPO has an obligation to maintain the equipment to a safe repair and condition, or sometimes operational repair and condition, rather than a full repairing clause within the lease. And those are the ones I just wanted to highlight. But as you can see in the slide, there are a few more at new consideration if you're acting for the CPO as well. Thanks, Michael. I'll hand back to you.
Yeah, thank you, Coralie. I think this is really important to sort of focus on those also from the landlord's point of view, because some of these are red lines for the CPOs, and there's no point sort of the landowners taking different points and trying to push things that are never going to fly, which I think is important when you're sort of choosing a law firm to represent you, to pick one that's got experience acting sort of both sides of the table, really. So landlords now sort of look at the other side of the property arrangements, and there's different ways a landlord could be involved. I mean, as well as sort of granting a CPO directly, which I'll come on to. Here I'm thinking of a landlord in a more traditional sense, where you might be a landlord with a sitting occupational tenant looking at EV. And there's three sort of key ways I think that you'll be asked to participate or approve EV being installed. And the first one there is where your tenant wants to install its own EVCI, which is nice and simple. They're going to own it, they're going to operate it, and typically you might get away with just a license for alterations to permit the works with a few quirks, but that's fairly straightforward. The second one, you might have a tenant wanting to permit a third-party CPO to install and operate the EVCI on terms we've just heard from Coralie, and there you're looking at sort of approving the subletting and also alterations probably. And then the third one, a lot more complicated, where you've got a tenant that might not have its own parking or sufficient parking for the EVCI requirement it has, and it needs EVCI to be installed in a shared car park, which is outside the demise, for use for them or their their staff or customers, and that can be a lot more complicated. Sort of permitting works out with the demise. So I'm going to focus on sort of landlord considerations in the context of granting a lease directly to a CPO, but all of these are relevant as well in those three scenarios I've just covered, because if you're approving your tenant entering into these arrangements, you also want to be thinking about the same sorts of things in terms of protecting your estate. And similar to Coralie, you don't have time, we could spend an hour on each of these slides, I think, but just focus on the key ones in bold I've highlighted as my top 5. And the first one is keeping an eye on redevelopment. You know, as a landlord granting rights to an EV operator to install, what are you going to want to do with that site or your retained land to the extent that it's bound in the near future? You know, these schemes can run for 10, 20 years. Do you want a cable running diagonally across a field next door with no lift and shift that frustrates that from redevelopment in the future? Might you need to actually redevelop your estate and move the EVC around or even terminate it? So it's good to sort of think that through, and I would say always try and negotiate sort of redevelopment or lift and shift rights. Even if it's at your cost as a landowner, having the right to do it is really important. If you're ever going to redevelop, you can factor that in as an additional cost, but not being able to lift and shift and sort of being stuck is obviously a very, very difficult position to find yourself in. So we typically look for lift and shift, not only with the CPO itself when their infrastructure, but if they're entering into easements and wayleys with DNOs and the like to bring power in, try and get them to negotiate lift and shift, and the ability to be a bit more flexible over your retained land there too. The next one I'll cover is car park regulations and policing. Again, another fairly practical point, sort of who's in charge of running the show, really. A lot of these CPOs aren't present on site, and they'll be monitored and run you know, from different locations. And these EVCIs could be, you know, in your retail premises outside your shop window. And who's responsible for policing them if you know, a diesel SUV parks in there in the morning and goes off for the whole day? Who's responsible for stopping that from happening? You know, who is imposing fines if that's allowed? Do you want a CPO imposing fines on your customers? Should you regulate how much they can charge? Who collects the revenue? Where does the revenue from that go? And it's that sort of thing, really. So who's kind of responsible on the ground, and what level of control do you want over what happens there? Branding and advertising. I mean, branding is fairly straightforward, I think, as long as your CPO is doing its sort of typical branding, colors and logos and things, doesn't usually cause too much of an issue. But advertising it is worth sort of focusing on and having a chat about what is envisaged, because a lot of these do have advertising on the side, which can be fixed or digital. And you know, in an extreme example, what you don't want as a landlord is to have, you know, Starbucks trading on the estate and have a competitor's copy brand sort of beamed on screens right across the way in through the windows. And we have an example at the moment we're advising an operator on an EV forecourt, and obviously they want to control sort of advertising in line with their retail strategy, but they've also asked the CPO for rights to use the digital advertising for their own sort of airport advertising. So it's not one size fits all, and it's just worth having on your list to sort of consider what do you expect and how much control do you want. Next one there, electronic communications code, so telecoms code, and these sites are served by data cables. You know, they do communicate sort of what's going on, where they're available, and they're managed remotely, as I said. And there is a risk that some of these cables in time could be telecoms code protected. And anyone that's dealt with development where you've got telecoms infrastructure realizes how difficult they can be to sort of relocate. And you know, if what we try and get in here is a covenant from the CPO that they'll do their utmost to prevent any of these data connections from becoming code protected. It's not something you can completely prevent, but I think at least having a covenant against it does give you a remedy that if the worst should happen, you might be able to sue for breach of contract and recover at least some of your losses. And if you have a covenant with the CPO shouldn't do anything naughty and go and register as a code operator. But if they're letting third parties run those cables, that is a real risk. And it doesn't come up a lot, but I think it's something we should have our eye on. We've seen it, you know, a few years ago in the water sector. A lot of water utilities were registering themselves as code operators so that some of their easements and wayleys could benefit from the telecoms code. And I think it might not be long before people in this sort of space wake up to that as sort of additional layers of protection. And then lastly, supplier licensing and reselling, which is really important. It is a criminal offence to onward supply electricity to a third party in some scenarios without licenses or from Ofgem, unless you can rely on one of the exemptions. And it comes up here. I mean, don't panic in terms of being a landlord of a multi-let premises, because you are exempt if it's on premises. If you buy power in bulk and sell it to your tenants under meter supplies and recharge, that's fine. Here we're thinking more probably off premises, where you might have EV outside and you're supplying a charge point operator with power. EVs and EVCI helpfully are exempt, but the retail might not be. So if you are supplying a forecourt with a coffee shop or a vending machine or something, it's worth kind of taking a step back and looking through how the power is actually being provided, who's buying and selling at which stage. Because if you do fall foul of this, like I said, it's the directors that could be liable to sort of criminal prosecution, which I'm sure Shreya will pick up in the sort of power slides. But I'll move on to Shreya to sort of cover power more general.
Yeah, sure. Thanks, Michael. So with a power strategy, there's really two key parts to this. The first is the grid connection setup, and then there's the procurement of the power itself. So we start with the grid connection. So there's two options here as well. So the EV charging infrastructure can have its own direct connection agreement to import electricity from the grid. Typically, given the size of these arrangements, the connection will be at distribution level. So you'll need to apply for an electricity import grid connection offer from the local distribution network, or otherwise known as the DNO. The other option you have is to share in the existing grid connection that is on site, and that's typically the case for commercial, industrial sites, ports, etc. In which case you'll be wanting to share in some of that import capacity from the existing connection. There's a few different ways that this can be structured, probably going from, let's say, least complex to most complex. First, you could have grid sharing provisions in the lease itself, or perhaps more common, there could be a bilateral grid sharing agreement that needs to be put in place with the existing grid connection holder. And then I'd say less common, there could be a gridco SPV structure. So that's where there's an SPV whose sole job it is to own and operate the grid connection, and become a shareholder in the SPV. It's probably a whole other webinar on the pros and cons of each of these, but the important point really with grid sharing is to try and ring fence as much as possible the electricity import capacity that you need to run the EV charging infrastructure, and also ensure that the costs and liabilities for that connection are shared in a way that are fair and proportional. And moving on to power procurement. So where are you getting your electricity from for the charging infrastructure? If we kind of cast our minds back to the diagram that we had in the beginning, kind of already alluded to two of these. So a few options. So you've got your utility import connection. So this is where you've got an agreement with a licensed electricity supplier to import electricity to the site via the public grid, so via the local distribution network. Also behind the meter generation, so more jargon, sorry. So behind the meter, that's getting power from assets which are not on the public grid, which are public grid side of the meter, sorry. So rather on the home side of the meter. So that could be getting power from your on-site solar, usually rooftop, or for an EV forecourt, that might be the solar canopy. And there's usually a mix of these two behind the meter and utility import connection and going on these sites. And finally, the corporate PPA, so see an increasing interest in power purchase agreements. So that's where you enter into a direct contractual arrangement to buy power from a renewable generator. It doesn't need to be located on the site, it can be located elsewhere. But I would say that's typically really only worth doing if you need a lot of power, you have a lot of imports. Otherwise, yeah, usually the first two options are more common. Thank you. Electricity supply licensing. So Michael's already mentioned this, but linked to this, all kind of underpinning a lot of this, is the supply licensing side. I'm going to go a little bit further and provide our customary kind of health warning when it comes to this area of law. So under the Electricity Act, the baseline position is that if you want to supply electricity, you need to have a license, or you need to fall under one of the available exemptions. The problem with the exemptions is that they were drafted in 2001 when EVs weren't widespread. So there's always some interpretation which is needed. If, however, as Mike's already said, you supply electricity without a license and without a relevant exemption applying, it is a criminal offence. And the key really for EV charging infrastructure comes down to this idea of premises, because in order to be supplying electricity for the purposes of the regulation, the supply needs to involve transporting electricity to a premises. And where the regulator has ended up is that the supply of electricity from the charge point to the EV is not premises, because EVs are not seen as permanent. So charge point operators would not be required to hold a license for selling electricity to the EVs. But the charge points themselves would count as premises because they're more fixed, I suppose. So persons who are supplying electricity to the charge points will be required to hold a supply license unless an exemption applies. And the key exemptions here around on-site supply and resale. Michael mentioned a kind of if a landlord is supplying power. So if the landlord has got that power from their licensed supplier and that's reselling onto their own tenants, one of them being the EV charging infrastructure provider, for example, then the landlord should be able to benefit from that resale exemption. Equally, if you've got on-site generation, so we talked in the beginning about on-site energy, so this, rooftop solar, for example, and that's where you're charging the EVs from, then again, there should be an exemption available there. In reality, there's often a mix of these arrangements going on. There might be multiple exemptions at play, but just to emphasize, it requires some careful checking because of the penalties involved. But on the whole, to be positive, if we find that supply is deemed to be going on at most EV charging arrangements, then most of the time they are exempt. But I will park that topic there and hand over to Tom on financing and leasing.
Thank you, Shreya. So I'm going to talk a little bit about asset leasing and some financing issues. And the most likely asset we're talking about will be EV charging infrastructure itself, but the same principles apply to electric vehicles or batteries, or indeed any other asset. I suppose the main wrinkles of this sort of leasing relate to the property law interface and the interface with the energy connection and regulatory position. So in its broadest terms, a lease is a contract for bailment, giving the lessee the right to use an asset for a specified term in return for regular rental payments and the obligation to return the asset at the end of the lease. The owner retains ownership, the lessee gets possession. And from the lessee's point of view, that's helpful because it avoids the substantial upfront cost, and there's no impact on its other credit lines. And lease payments may be deductible as an operating cost. So the most basic decision is whether the lease is going to be an operating lease or a finance lease. And this is fairly sort of standard and basic stuff, but under an operating lease, the risk and rewards of ownership remain with the lessor. The operating lease rentals cover just a portion of the asset value plus a return on investment in the form of interest, and the owner retains the residual value risk or the releasing risk, which is also a potential releasing opportunity. Under a finance lease, the lessee will take the risks and rewards. The finance lease rentals will cover the entire asset value plus interest, and there will be a de minimis purchase option at lease end. This distinction between operating leases and finance leases used to be more significant prior to the introduction of accounting standard IFRS 16. But nowadays, all leases have to be reported on balance sheet as assets and liabilities, apart from leases with a term that's shorter than 12 months or for particularly low value assets. Capital allowances might be an important consideration. For a long funding lease, which is generally 7+ years, the lessee will get the capital allowances, and for a non-long funding lease, the lessor will get those capital allowances. So much for the basic structure. Once you get into the nitty-gritty of the actual lease agreement, there are certain standard clauses in any asset lease, one of which is the hell and high water clause, meaning that the lessee's obligation to pay rent applies pretty much regardless of whatever happens. And that's a sort of an article of faith in asset leases. The lessee will have the right to quiet enjoyment, providing that it's complying with its obligations. And if it is not, the lessor will have the right to take possession of the asset and go again. Now, in an operating lease particularly, the residual value of the asset will be key, because obviously the releasing is the way that the lessor will recover its initial investment in the asset. So maintenance obligations come under a lot of scrutiny in an operating lease, and there will be a detailed return condition obligation at the end of the lease. So in terms of the maintenance obligation, the lessor needs to know that the lessee has the capability, the expertise, the resources to perform maintenance properly. There will be certain information covenants to give visibility as to what's going on, and obviously a raft of remedies if there are problems. The return condition is supported by inspection rights, and obviously you wouldn't expect a lessor to wait until the end of the lease when redelivery is imminent and then find out what the condition of the asset is. So these inspection rights would be periodical, and they're usually accompanied by a right to call for redelivery security, which might take the form of cash collateral or a parent company guarantee. The point being that a lessor doesn't want to end up with a claim against an insolvent or demotivated SPV at the end of the lease. Those obligations are supported by detailed operational undertakings, which would cover things like restrictions on subleasing, inspection rights, as I've said, maintenance repair obligations, and provisions relating to the right to modify the equipment, which obviously the lessor will want to have visibility and control over. And as Coralie mentioned earlier, where there's external financing, there will be a requirement from the financier to have a direct agreement, which will give it step-in rights if there is a default. A slight oddity of this sector is I've encountered quite a lot of resistance to direct agreements, and I think that's born out of a lack of familiarity. But I suppose the point to make there is they're unlikely to be negotiable, and they're probably helpful in that they offer the scope to keep a project on foot if it runs into problems, and avoid all of the general disruption and associated upheaval if there is a termination. Now, I was hoping to move on to the next slide, but it stopped working. There we go. Turning to financing, I mean, there is as I'm sure everybody knows, quite an appetite for financing. You know, banks have ESG commitments, so this is an attractive sector to get into. But of course, there are a number of challenges, and the most significant challenge is the unpredictability of revenue streams. Now, these sort of schemes might be financed by corporate debt, but that's very much dependent on whether there is capacity for that. Developers like project finance, where the lenders look only to the future earnings and assets of the project as a source for repayment, with limited or no recourse to the developer, which is obviously very attractive. The financier's concerns will be the high upfront costs of the kit, the risk of obsolescence and the pace of technological change, and as I said, the unpredictability of revenue streams, which are obviously key to debt service. The potential mitigants are, so I suppose, economies of scale. So if you have a fleet financing or a land bank or a large number of assets, that reduces the risk and enables a sort of debt service coverage ratio type financing. The arrangements with the off-takers will be key to the credit analysis, and certainly if there are minimum pricing arrangements, that will help, as will government support, which might take the form of grants, as we've seen. Finances are likely to require a reasonable level of equity investment, and that obviously reflects the risk that they're taking. And all of this will be supported by a detailed security package, reporting obligations, and the usual raft of contractual protections. So turning to security, you might have project level security and revenue security. So security over contracts is a likely form of security. You'd have assignments over the key project documents, for example, with power suppliers, maintenance providers, landowners, and so on. You might have security over the physical assets, so the charging equipment, which could take the form of a chattel mortgage or a fixed charge over the assets. You might have security over real estate or security over the accounts into which the revenues land. As for revenue security, there's contracted revenue. So finances might want to take security over fleet charging or charging as a service arrangements, particularly where there's a guaranteed revenue stream. The finances will use data analytics to predict revenue, and if those stack up, that will make the project more bankable. I mentioned obsolescence as a key risk and concern for financiers. Of course, there's a scope for it to be an opportunity as well, if technological advances might improve costs in the future. And offtake agreements I've already mentioned. Another risk mitigation feature would be the use of a debt service reserve account over which security would be taken. That would be to ring fence a sort of minimum level of cash flow for debt repayment, even during periods of low revenue. So that's a bit of a whistle-stop tour through some of the leasing and financing issues. And I'll hand back to Michael.
Thank you, Tom. I think Emma's still stuck in the car. I think Shreya, you're going to have a go at presenting these slides based off Emma's notes, which we're very grateful for. So,
Fine.
but before you get going, we just remind everybody that we have got the Q&A function, and we'll have time for Q&A. So if you have got any questions, pop them in the Q&A chat, but maybe not on procurement in case. We'll have a go. But
we'll have a go. Yeah.
Thanks.
So I'm gonna do a little bit on private sector procurement, and then the rest of the session will be covering public sector procurement. So as Michael's mentioned at the start of the session, often the drive for installation at a site will be the tenants, so the office occupiers, the retail tenants, etc. However, there will also be some drivers for landlords as well to run their own procurements for EV charging on their sites. They might have ESG commitments as a business requirement, or need to fulfill certain ESG requirements due to pressures from their lenders to make their business more sustainable. Typically, rather than the full-scale tender that you might see in the public sector, landlords will often run informal RFPs or negotiate directly with EV charging operators. Typically, these will be for single sites or based on a portfolio rather than the kind of region-wide tenders that we see in the public sector. Generally, the commercial models for this will either be landlord-owned, common if the landlord wants revenue certainty and obviously a certain degree of control, or concession operator-funded, used when the landlord wants minimal capex and quick deployment, and wants the risk to sit with the operator. And moving on to the next slide, please. Thank you. So public procurement. So contracting authorities, CAs, are increasingly looking at procuring EV charging infrastructure under public procurement. So some recent examples of this are on the slide, some of which are ongoing or in preliminary market stages. Public procurement of EVCI can present opportunity for both operators and contracting authorities. For operators, there's the opportunity to tender for the procurements, but it's really key to understand the procurement rules to bid well and bid compliantly for procurement to maximize, obviously, the chance of being successful in the tender and kind of ensuring you fill as much of the evaluation criteria as possible, and even keeping good engagement with the authority, even if you're unsuccessful, so you're aware of future opportunities. And also to understand challenge risk, so the risk to the potential threat that if you are a successful bidder of a challenge, based on if the bid was awarded on a non-compliant tender, and understand in that situation what kind of recourse you might have. So the key here is to understand the rules so that you're not disqualified from procurements as you've not filled out something correctly or forgotten to submit, for example, a kind of compliant procurement specific questionnaire, setting out your financial position. For contracting authorities, it might also be useful to engage with other contracting authorities to discuss lessons learned from them before you commence your full procurement process. And next slide. So you see kind of two main delivery models here when it comes to public procurement, own and operate, and then the concession model. So with own and operate, the contracting authority funds and runs the EV charging infrastructure, taking operational and commercial risk for long-term control and revenue. Then there's the concession model where the private operator installs and operates the infrastructure, takes on revenue and risk, and that's often used when you want a rapid scale up and also obviously leveraging private expertise as well. EVI funding often drives concession use because it supports public-private partnerships and requires risk transfer to the operator. Under the Procurement Act as well, 2023, concession contracts fit where the supplier kind of does the works and bears the real operating risks. So whereas if you use the competitive flexible procedure that allows for negotiations, that's ideal for more complex projects. But really key, before choosing a model as a contracting authority, you need to prepare a robust business case and secure internal approval, getting early legal advice, of course, on a procurement route and contract form to reduce the risk of challenge and ensure compliance with the Procurement Act, particularly on transparency, Section 12, and proportionality, Section 19 of the rules. For bidders as well, worth checking the funding requirements, confirming that risk revenue structure, and also reviewing the output specification as well to make sure that you are compliant. Next slide. So the potential routes for contracting authorities are to use an existing framework agreement or to run a competitive flexible procedure under the Procurement Act to procure works and services, and same applies to EVs just as it would to any other work and service. Unlikely that given the value of the potential EV contracts that a direct award is appropriate, as more likely than not it will exceed the procurement thresholds which are set out on the slide. In terms of the procedures, if a framework or DPS is used, and the rules of the framework or DPS will apply. So you kind of check what it is, and if there are mini competitions as part of this, and so if you'll either as a contracting authority need to run the mini competition in accordance with the rules of it, or as an operator you'll need to be aware of and choose whether or not to participate in the mini competition. For the own and operate model, the contracting authority will have the operating risk, so it might want to look at the existing framework to reduce the costs of negotiation. And there are also other frameworks as well, examples like the CCS framework as well, or an open procedure which they can use. For concession contracts, then the competitive flexible procedure is likely to be the most appropriate given the likely value and complexity of the contracting model. And next slide. And so just a bit on on-street solutions when it comes to EV charging infrastructure. So sort of a slight segue, but we'll go back into public procurement in a second. So firstly, a Section 50 street works license needs to be granted by the Highways Authority in order to carry out works on public highways. It's issued to the owner of the apparatus, not the contractor, and a single license can cover multiple sites. So it's key that the procurement aligns with the license scope. The contracting authority should check it, and the bidder should do their due diligence to make sure that's correct. And then finally on planning permission, so it's needed in the circumstances which we've set out on the slide. So for full planning permission is needed where they permitted development rights aren't available, for example, or for charges which are part of on-street parking. And permission is also needed for pavement crossings unless they are owned by the Highway Authority. I've got some key tips on here in the pink arrow. So again, contracting authorities should include these consents in their procurement schedules and risk plans to avoid delays and compliance issues. And bidders should verify these factors are reflected in output specifications and their timelines. And so we've included some common pitfalls for public procurements and proposed mitigants on the side. We're not going to go through these in depth today, but we thought it would be useful so you could have these as part of the slide pack that we'll send around afterwards. But some points to consider that are that some of these apply to both contracting authorities and bidders operators. So lack of prior market engagement, for example, this applies to contracting authorities, but would also flag to operators that it can be useful to participate in market engagement exercises to help shape procurements you're interested in. Obviously, there's also a balance to be struck there. There's no guarantee that participating will mean that you're selected in the procurement, but always useful to consider. And for site feasibility as well, if there are concerns about this from an operator or in procurement, we'd recommend raising these early on, as it might be too late later on if there's a flaw in the technical specification that's later found. And that's it from me. Move on to the questions.
Brilliant. Thank you, Shreya. Thanks for stepping in for Emma there on that. Really grateful. Yeah, keep your Q&A coming through. There's a couple of questions that are coming through now. The first one, which I'm just going to pick up, I'll talk to first, and I might come to Shreya and Tom for comment if you want to add anything. But the question is, what do we think the future of EV charging looks like? Do we think political changes could shut down the industry? Is it more likely that we're moving towards opportunity or obsolescence? And for me, kind of looking at sort of EV from what I've seen, it looks like it's going to win the race, particularly for sort of domestic cars and small trucks and smaller vehicles. Maybe not so much on the larger ones, but there was a feeling a number of years ago, where EVs were competing with hydrogen cars, for example, and I think due to the lack of hydrogen charging infrastructure versus now where we are with EV charging infrastructure and sort of availability to charge your car at home and on the road. And some of the new cars coming out. I mean, there's a car, I won't mention the brand, because I think we have attendees on this webinar from the brand, but there's cars now hitting the market with 500-mile range, and stuff. So things like range anxiety, I think, are diminishing as well as some of the sort of very smart sort of energy sort of contracts you can have with your supplier on sort of when and how they sort of charge the EV, maybe take power back, or even charge the EVs at home when they're negative electricity prices. You actually get paid to charge your car. It's just all things are pointing towards, I think, quite a successful future for the EV market and the charging infrastructure that's needed for that. I don't know, Tom, if you wanted to add anything, given that you mentioned obsolescence, whether I sort of covered your thoughts too.
Yeah, you pretty much have. Thanks, Michael. I mean, I think it's hard to crystal ball gaze as to where we'll end up, because it seems for an old man like me, it seems relatively recent that we were all being encouraged to buy diesel. Things have obviously moved on since then. I think one of the challenges is the pace of technological change. My hunch, and this is uninformed comment, is that the sort of EVs are here to stay, and that whilst the underlying technology may change, in principle, I think EVs remain the future, but you'll be able to find someone who'll disagree.
Thank you, Tom. Shreya, do you have anything to add?
Not much to add, and I'm of course biased because I'm an electric first person, and I see that's the route for decarbonisation, and that's the way the current government policy is pushing, and always has been, actually, regardless of what government is in power. So I think that will only continue, and obviously, as Michael's already talked about, with kind of electric being the way forward in homes as well, then EVs fit nicely with that, as well as on a commercial scale.
Brilliant, thank you. Yeah, keep your questions coming. One for Coralie. Sort of, you mentioned fundability a couple of times on your slides, I think. What's the importance of fundability for a CPO? Why does it matter?
Thanks, Michael. I think generally it's really about making the lease more favourable for investors and lenders. It ensures that the lease is of quality that is assignable, and minimises any need for changes later on, which can be cause delays, or if you need to vary the lease, or additional costs. And more generally, it's considered to be quite a balanced position, and it sort of standardizes different EV leases across the market as well.
Okay. Thank you, Coralie. We've had a question on the Procurement Act, which I think Shreya's going to have a go at answering. So it's saying that frameworks are not permitted under the Procurement Act 2023 for concession contracts. So that will be a limitation on the contractors. They can't set up new framework agreements for concession contracts. And the question is, do we have any experience of joint procurement for concession contracts, and what are the challenges? Shreya?
Yeah, so there may still be some existing frameworks which are running. So we've seen a Crown commercial one that ran until 2026, but unlikely that that can be joined if kind of already don't fall within it. But worth checking as the definitions of who qualifies for these frameworks is quite broad. On joint procurement for concession contracts, where we've seen it done successfully is usually when it's run through the same combined authority or group of councils with one lead council that's nominated as a contract counterparty. In terms of challenges, sort of the same as there are with any multi-party contract in terms of aligning governance internally, particularly on risk profile of the contracts and where control that each authority would have in its own area, how revenue is split, getting liability sign off for the party, that is the kind of contracting entity to that contract. What else to say? So you could also try and do it with multiple counterparties under joint procurement rules, but we've not seen it done sort of successfully due to the challenges of getting everyone, again, to align on risk and getting governance sign off. So it really does work best where there's one leading contracting authority or combined authority running it for that reason.
Brilliant. Thank you. I've got one more question. So we have got another 9 minutes. If anyone has got any final Q&A, please pop them in the chat. But my question to you, again, Shreya, sorry, is I keep asking you the same question, but how does the electricity licensing rules work on the sort of public street charging side of things?
Yeah, sure. I mean, long story short, it is usually a bit simpler, which is nice. So public charge points or on-street charging, usually these charge points are directly connected to the public grid, to the local distribution network. And the arrangement is that a licensed electricity supplier will be directly supplying electricity to the charge point. So supply licensing is usually kind of less of an issue because normally you already have a licensed supplier involved that's doing the heavy lifting. And you don't normally need to get into the weeds of the exemptions. It would be a bit different if the electricity is being supplied to a landlord who is then supplying it to domestic residents, for example. But on the whole, it's usually simpler from a supply licensing point of view. On the flip side, though, with public charging comes sort of other challenges, other regulations to be aware of, like the public charge point regulations, for example. So there's different challenges when it comes to public charging.
Thank you very much. Well, that's all the Q&A that's come through, as we have managed to answer all of the questions. So thank you for engaging with those, and I hope we've answered your questions satisfactorily. Our contact details are there on the slides. If there's any follow-up questions or you want to get in touch with any of us, please do reach out. We would love to hear from you. And a thank you for all of you for attending, but also to all of our speakers. We will be sharing links to the slides. There might even be a recording, I think. But yeah, thank you very much, and enjoy the rest of your day. Thanks all.